Time now for Night Court. When the Queen of Soul passed away in 2018, her family believed she did not have a will. That was until two handwritten documents were found at Aretha Franklin's Detroit home. One dated 2010 was found locked in a cabinet, and another dated 2014 was found in the singer's couch. For more than 4 years, the soul singer's family has been divided over those documents. Today, a jury ruled that the 2014 document should serve as her will. But did the jury get this one right? And are the legal fireworks over? Let's bring in trial and criminal defense attorney Lexi Rigdon, along with criminal defense attorney and federal litigator Vikas Bajaj. Welcome to both of you.
Thank you.
Thanks, Mike.
Exhibit A, let's take a look at the March 31, 2014 will, which includes the phrase being of sound mind. Vic, looks like a draft. Why is this good enough?
Well, the ultimate question for the jury is what was her intent? And it's not pretty, and there are scribbles, and there are errors and corrections, even smiley faces and signatures with her name on it. But it's enough to pass muster because it's enough to show what her intent was. We'd prefer a lawyer actually draft something notarized with the proper inclusions, but that wasn't there. But that in the state of Michigan is allowed. We're allowed to have handwritten wills, and that's in fact what the jury found in this case.
Exhibit B from the Detroit Free Press. Jurors heard closing arguments from attorneys Tuesday following Monday testimony that focused in part on the Queen of Soul's signature, A. Franklin, with a smiley face toward the bottom of the 2014 papers. White's attorneys did not dispute the signature's authenticity, but rather its placement on the page, saying it was merely a reference to some notes in the text. Lexi, why, in your view, did the jury get it wrong?
Mike, I have no RESPECT for this decision. The jury obviously believed by reaching this verdict, which was surprising that they reached it because they had 2 days of testimony and they reached it in less than an hour. And 2 days is not nothing. That's a lot of testimony to parse through. But I'm surprised that they came to this conclusion because the 2010 will was very different than the 2014 will. The 2010 will was locked away. It was much longer. It was much more detailed. It was notarized, and it contained protective things in there, including, requiring that some of her children actually take business courses before they're able to collect. Now, the 2014 will, in stark contrast, it was in the sofa, it had the smiley face, it didn't have the formality, it wasn't notarized, and then you just look at the overall context of the fact that she went to some lengths to protect her assets, and she's Aretha Franklin. She's a legend, and she's very wealthy, and it does not make any sense that she would shove this piece of paper that was so important in the couch if it were in fact her last will and testament.
All right, Exhibit C from AP. White, who played guitar with Aretha Franklin, testified against the 2014 will, saying his mother typically would get important documents done, quote, conventionally and legally and with assistance from an attorney. He did not immediately comment after the verdict. What about that argument, Vic?
Well, in Utopia, that makes sense. And while we wish, again, that she had consulted an attorney like we would all expect, and like the 2010 purported will shows, that's not what's required. And while we have comments saying we wish it were different things, and we wish that it had these caveats requiring the beneficiaries to establish certain things, such as a proper education or financial training, the fact of the matter is the law states otherwise. It's not Utopia, it's practicality, and that's in fact why it passes muster.
All right, Lexi, final word from you.
All I can say is that I say a little prayer for this family, that they can put this behind them and move forward and mend their fences.
Lexi Rigdon, Vikas Bajaj, thank you both for your time. Have a great night.
Thank you, Mike.